Munir Arbison, Ferdinand Hernandez, Frederick Abueg, Evelina Escudero. The Honorable Majority Leader Renando Andaya, the Honorable Senior Deputy Majority Leader Rodante Marcoleta, the Honorable Deputy Majority Leaders Arthur Defensor Jr., Cristina Chiqui Roapuno, Ann Hofer, Vincent Quisologo, Wiltor Sharky W. Palma, Victoria Isabel Noel, Ron Salo, the Honorable Minority Leader Danilo Suarez, the Honorable Senior Deputy Minority Leader Jose Atienza Jr., and the Honorable Deputy Minority Leader Garbin Jr., Anthony Bravo, Luis Jose Angel Campos, and the Honorable Chairperson of the Committee on Accounts, the Honorable Yeda Marie Romualdez. Your Honor, the roll call shows that 15 regular and ex officio members responded to the call.
There being 15 members who are present, the Chair declares a quorum. May we request the Committee Secretary if we have the minutes of the previous hearings for approval.
Mr. Chair.
Yes, you are recognized, Vice Chair Henry Ominal.
The minutes of the January 23, 29, February 7, 12, 9, 27, and March 9 and 19, 2018 meetings are hereby circulated to the different members of this committee. And in that connection, Mr. Chair, I move to dispense the reading of such particular minutes as mentioned earlier.
There is a motion to dispense the reading of the minutes and a second. There be a second. The Chair hears no objection. The motion is approved.
Mr. Chair, with the approval to dispense the reading of those minutes, I therefore now move for the approval of the same.
Second motion.
There being a motion and seconded, the Chair declares approval of the motion. Again, good morning to each and every one of you. Good morning. Yeah, good morning to our dear members and of course our dear complainants, and so with the guests and our dear Filipino people. Today marks another cornerstone, or actually an event in the history, as we are tackling another impeachment complaint. So for the orderly proceeding, we will be dealing first with the opening statement of the Chair, so followed by the opening statement of the complainants. And then from then on, we'll be discussing the ground rules for the orderly proceeding of these impeachment complaints. And let's proceed from there. If there are certain motions that need to be disposed of, but definitely we'll be dealing with the form of the impeachment complaints. So kindly allow this, our dear members, this Chair, to have this opening statement. More than about less than 6 months ago, and when we terminated our impeachment proceeding against the former Chief Justice Maria Lourdes Sereno, and barely less than a month when the President of this country, President Rodrigo Roa Duterte, appointed the new Chief Justice, the House of Representatives, which has a sole jurisdiction over the power of impeachment, particularly we as members of the Committee on Justice, are once again tasked to perform a constitutional mandate under the Constitution of demanding and extracting public accountability from the highest officials of the land. In some cases, referring to the members of the Supreme Court. The present controversy at hand definitely presupposes at least those filed before the Committee on Justice actually proves two things for me. First, that the filing of the impeachment complaints is actually indicative that democracy is actually vibrantly working in this country. I mean vibrantly working because we Filipinos, as we always are innately possessing the innate power or distinctive power to question possible abuses being committed by any public official warranting the removal from public office. Time and again, we have been saying that democracy is the bedrock of this nation, and for which is always a reason that this country is always mighty proud as viewed from the rest of the world. Second, for me, the filing of these impeachment complaints actually proves that there is no smoking gun in the Constitution, that there is no specific provision under the Constitution which actually shields any impeachable officer, particularly the justices of the Supreme Court, from being removed to public office or from public office. There is in there, in the primary instrument of the land, that guards the justices from committing abuses. And definitely, this is impeachment. Again, very clear to us that the members of the Supreme Court may be removed from public office. Crystal clear that no one is above the law. And this is democracy. True enough that this aspect of democracy, although embedded in our Filipino culture, can definitely be traced back in centuries of history. Back in the 14th century, when the British government actually adopted its own brand of impeachment, wherein the impeachment proceeding was akin to a criminal proceeding where the ultimate objective is punishment of imprisonment, even going farther up to execution, wherein the House of Commons would serve as the prosecutors and the House of the Lords would serve as a judge. Similarly, in the U.S. Constitution, in the federal government of the United States, the House of Representatives would initiate the impeachment proceeding, and then the House of Senate would sit as a judge. Very exactly the same arrangement that we have now in the Philippines, wherein this House of Representatives has sole jurisdiction to assume the power over the impeachment complaints as the bastion of democracy. But probably you may question, is it this democracy that all matters? For the information of everyone, this is actually the fourth impeachment complaint that was filed in the 17th Congress. If I remember it right, when I was still Vice Chair of the Committee on Justice of this very same committee, we remember sometime in May of 2016 when an impeachment complaint was filed against the President of this country, filed similarly by one of the complainants herein, Congressman Gary Alejano. The second one was filed against Comelec Chairman Andres Bautista, which was filed by then Congressman Harry Roque and Congresswoman Gwendolyn Garcia. The third and fourth impeachment complaints were filed against the former Chief Justice Maria Lourdes Sereno. Out of the four impeachment complaints, the first three were dismissed and found to be insufficient in form and in substance. The only fourth one was found to be sufficient in form and substance, that was filed by Attorney Larry Gadon, for which reason the impeachment proceeding proceeded until the termination of probable cause, until the finalization of the articles of impeachment. Today, as we begin our deliberations of these impeachment complaints, no less than against the Chief Justice of the Supreme Court, Chief Justice Teresita Leonardo de Castro, together with the 6 Associate Justices, namely Lucas Bersamin, Alexander Esmundo, Francis Ardiresa, Diosdado Peralta, Andres Reyes, and Noel Tiham. My dear colleagues and my dear members of this committee, I know you are all apprised of the situation now in this country. The filing of the impeachment proceedings that we have right now, although to be dealt with independent judgment of the members of the committee, may again request that we should be reminded with the following tenets in dealing with impeachment complaints. Number one, the impeachment proceeding is actually a sacred process under the Constitution to ensure public accountability and should not be treated just like filing an administrative complaint. Second, while the truth and justice are the primordial consideration in disposing of these impeachment complaints, we should also be reminded that the integrity and stability of the major institutions that we have right now should be given with equal significance of consideration. Third, while the impeachment complaint can be regarded as politically or political in nature, this should not be and must not be a political circus. And lastly, while this impeachment complaint is actually anchored on serious and exclusive offenses, this should not be treated to be the only tool to remove a public official, because the ideals of those impeachable officers do not align with the ideals of the complaining parties or the impeaching authorities. At this juncture, my dear colleagues, our dear guest, maybe you would ask, what is actually the principal issue at hand right now? Very simple. The allegations set forth by the complainants, namely Congressman Lagman, Congressman Alejano, and Congressman Teddy Bagilat, they actually allege that the respondent justices, knowing fully well that the only mode of impeaching or removing impeachable officers is only through impeachment, those said justices actually arrogated upon themselves the power vested upon the House of Congress to impeach impeachable officers when they assumed jurisdiction and dispose of the co-warrant to proceeding against the former Chief Justice Sereno, resulting the ouster from her possession as the highest magistrate of the land. For them, the acts committed by the justices simply constitute culpable violation of the Constitution and betrayal of public trust. On the contrary, however, some authorities would claim, can the respondent justices' actions in assumption of jurisdiction and disposition of the case, assuming ex argumenti that these cases actually are error of judgment and alleged to be unconstitutional, are those actions tantamount to impeachable offense as to warrant their removal from public office? These actually are significantly the most intriguing questions that we as members have to decide following the rules of procedure. For the past months that we have witnessed the filing of criminal complaints or impeachment complaints, I know all of the members are already well versed of how the impeachment complaint would proceed. But kindly allow me to at least recite very briefly the important notes that we have to consider, mindful of the fact that we have to deal with these impeachment complaints with utmost transparency, impartiality, and of course to fasten up these proceedings. Particularly under Rule 3, Section 4 of the Rules on Impeachment, it is particularly stated there that upon the due referral by the plenary, of course coming from the Speaker, to the House Committee on Justice, the first thing that we have to do is to determine whether the impeachment complaints would pass the test of sufficiency.
This is the newsroom on CNN Philippines.
In order to determine whether the complaints would pass the sufficiency in form and substance. But on the subject of form, there is actually a requirement under the Constitution. Number one, if the complainant is filed by any citizen of the Philippines, it should be verified, of course. Second, to be endorsed by any member of the House of Representatives. Second, the second mode will be by the filing of the impeachment complaint by any member of the House of Representatives. Of course, it should be verified also. And in all cases, and in both cases, that impeachment complaint should conform with the one-year bar rule, meaning the impeachment complaint should not be filed within the one-year period following the dismissal or termination of the previous impeachment proceeding involving the same case. Second, assuming that the impeachment complaint would pass the test of sufficiency in form, then under the rules, what we have to do is to determine whether the impeachment complaint would pass the test of sufficiency in substance. It is very clear under the law and under the rules that the test of determining the sufficiency in substance would definitely be by taking into consideration the recital of facts as to constitute the offense charge and determinative of the jurisdiction of the House Committee on Justice. If the test of sufficiency in substance would be in the affirmative, then we would see what happened or the following the determination of probable cause as we have seen during the impeachment proceeding against the former Chief Justice Maria Lourdes Sereno. In summation, the extraordinary impeachment proceeding is actually enshrined under Article 11 of the 1987 Constitution, which provides that the House of Congress shall have the exclusive jurisdiction to determine the materiality of those allegations in the complaint. Again, I would like to reiterate that the independent judgment of the members of the House Committee on Justice would prevail. And in a democracy such as ours, in a democratic country like ours, I think the majority will prevail. Ladies and gentlemen, our dear members, before I end, I would like to at least quote this very important article that I read over the weekend. And actually, this is actually what we have to deal with these cases. We have to consider, of course, impeachment as a very powerful tool to remove public officers, particularly impeachable officers. But, of course, on the other hand, the experts have this to say. An impeachable offense is a necessary but not sufficient justification for impeaching and removing an officer. Some bad acts can be tolerated. Some call for less drastic responses rather than extreme measure of impeachment. So Congress has frequently tried other methods of reining in bad conduct before looking into impeachment. Impeachment solves a political problem, not a legal one. It responds to threats to the constitutional order, not civil order. This being said, the implications of the proceeding that we're having right now definitely would be far-reaching. For example, if the 7 justices would be removed and turn out to have committed impeachable offenses, half of the membership of the Supreme Court would be empty. And definitely, half of them, as they say, would be called as designated survivors. But nonetheless, the complainants should not worry. Because while those things or statements are being said, we likewise also recognize the fact that the impeachment proceeding forms part, as an integral part, of the Constitution with respect to doctrine of check and balance. Thus, for all members that we have right now, may we remind everyone to observe the sanctity of this impeachment proceeding. I encourage everyone to observe the highest standards of discernment in performing our constitutional duty to determine whether these complaints are actually factual, legal, and sufficient in form and substance. And if I may say, I would like to repeat endlessly that this committee would treat your administrative or impeachment complaints with utmost transparency and, of course, with utmost impartiality. Thank you, and again, good morning. Okay, my dear colleagues, first, we'll set the ground rules. After this statement, we will allow our complainants to say their piece, at least to lay the ground, or at least the factual and the most important allegations of the complaint. Second, each member shall be given about 5 minutes. Third, if you wish to add more, you'll have your second round with 3 minutes. And then, of course, we will be guided by the rules of the impeachment proceeding with the internal rules of the House of Representatives as supplementary rules. So now, we would like to recognize Congressman Lagman, who's going to speak in behalf of the complainants. By the way, I would like to tell you, you have actually a query before we started our meeting that under the impeachment complaints, there are actually 4 names. But then it's very clear under the law, even under the civil procedure and even under the rules of court, that if an impeachment complaint or any other complaint or petition for that matter that was not signed by the complainant, that impeachment complaint shall be considered unsigned pleading and therefore a scrap of paper. For the jurisdiction information of everyone, we will already recognize 3 complainants in these cases, in which case Congressman Ed Selagman, Congressman Teddy Bagilat, and Congressman Alejano. I am sorry, Congressman Villarin, because you were not able to sign the impeachment complaint, you are not considered complainant in this case. Congressman Lagman, you may proceed, please. Well, of course, we have first to recognize Congressman Lagman.
Thank you, Honorable Chairman and distinguished members of the House Committee on Justice. Thank you, Mr. Chairman, for your impartial and judicious opening statement, which the complainants will partially adopt as part of our opening statement. Mr. Chairman, distinguished members, we have filed these impeachment complaints for the following overriding reasons. 1, we are of the firm position that the respondent justices committed a culpable violation of the Constitution on 2 grounds: for usurping the sole power of the Congress to impeach the highest officials of the Republic and arrogating the sole power of the Judicial and Bar Council of vetting the qualifications of aspirants and nominating the candidates for judicial positions. And B, blatant betrayal of public trust, when 5 of the 7 justices, despite their admitted persistent ill will, bias, and prejudice against the former Chief Justice Maria Lourdes Sereno, refused to inhibit themselves from adjudicating the improvident and irregular quo warranto petition against Sereno. 2, we do not want to condone the knowing rendition of a malicious and unjust judgment by the 7 respondent justices, which is offensive to the Constitution and violative of the requisite impartiality and judiciousness of neutral magistrates. 3, the decision of the respondent justices is not only a mere, quote, error in judgment, unquote, but a malevolent, spiteful, and orchestrated decision to oust a Chief Justice against whom the majority of the respondent justices have admitted continuing ill will, bias, and prejudice. 4, afford the people the right and opportunity to exact accountability from errant and conspiratorial justices who have wittingly rendered an unjust and unconstitutional decision. 5, regain the prestige, independence, and objectivity of the Supreme Court, which have been tarnished and eroded by the controversial and unconstitutional ouster of Sereno. And 6, reclaim for the Congress the sole power to impeach the highest officials of the Republic, which power the 7 justices arrogated, and which the House of Representatives under the former leadership forfeited by not pursuing to its finality the impeachment proceedings that it has already started and was about to terminate when the subterfuge quo warranto petition was filed with the Supreme Court. Mr. Chairman, distinguished members, yesterday I filed a letter addressed to the chair, copy furnished the members of the committee, justifying why the impeachment complaints are sufficient in form and substance. If necessary, later I would reiterate the arguments we put forward in this letter. Thank you so much for this opportunity, Mr. Chairman.
Thank you, Congressman Nagman. Before we proceed, would you like to say your statement, Congressman Alejano?
Thank you, Mr. Chair. Good morning. Again, to the chairperson, Representative Doy Silachon, members of the Committee on Justice, my dear colleagues, guests, ladies and gentlemen. Today, we are once again placed in a familiar but unnerving situation as we start the grueling process of impeachment. Admittingly, the impeachment process will consume much time and energy from this chamber, but it is a process that we must traverse in order to protect and regain the independence and confidence of our people to the judiciary. I maintain that the 7 Supreme Court associate justices, namely Justices Teresita de Castro, now the Chief Justice, Diosdado Peralta, Lucas Bersamin, Andres Reyes, Francis Ardelesa, Noel Tiham, and Alexander Gismondo have committed the impeachable offenses of culpable violation of the Constitution and betrayal of public trust by granting the quo warranto petition to remove the former Chief Justice Sereno. The impeachment complaint that we have filed in the impeachment process that we are initiating today is the proper and legal venue to seek accountability for their action as provided in the Constitution. Ito lamang ang tanging kaparaanan upang panagutin ang mga impeachable officials sa paglabag ng ating saligang batas. Wala na pong iba. Through this hearing, this chamber will initiate and hear the impeachment complaints against the 7 respondents, a mandate provided by the Constitution to this chamber that was otherwise conveniently stolen by the quo warranto petition. Today, dear colleagues, we are presented with a great opportunity to correct and halt the wrongs that will tend to weaken our democracy and strengthen injustice and oppression. I hope that we respond appropriately in order to restore the independence and integrity of the judiciary. Maraming salamat po. God bless us. God bless our country. Thank you, Mr. Chairman.
Thank you, Congressman Alejano. Yes, Congressman Villarin, you have something to say?
Yes, thank you, Mr. Chair. Mr. Chair, I would just like to manifest my intent to affix my signature in the impeachment complaint. As you all know, I was not able to make it to that filing because of an emergency in Davao where I live, Mr. Chair. But I do have personal knowledge in the making of such complaint. And as early as 2 months ago, I have been publicly telling through the media of my intent to file an impeachment complaint against the then 8 justices. So, Mr. Chair, if the committee will allow it having the jurisdiction to amend the complaint, may I take an oath and swear before the committee that I do have personal knowledge of the contents of this impeachment complaint. For your consideration, Mr. Chair.
Yes, thank you, Congressman Villarin. Well, as I said earlier, as much as I really want to accommodate your concern, but then, of course, we are always be governed by the rules. In fact, even that intention cannot be, of course, with all due respect, that cannot be even accommodated because there's only one way of you being a complainant in this case. After all, we are already acknowledged. In fact, the complaint would even stand, even without your signature, but to accommodate you as additional complainant for the very first reason that you were not able to sign, under the law, even under the rules, it is considered an assigned pleading. If it is unsigned pleading, that is considered a mere scrap of paper. And in fact, and for which reason, as if nothing existed at the time as of this moment. And to permit you definitely is, of course, we want to start it right. But if we will accommodate that one, that will be another bend of the rules regarding the acceptance. Primarily, number one, ang sabi ng ating kagalang-galang Edsel Lagman ay may question pa nga doon sa pag-appoint kasi dapat na laman daw ng JBC na nag-file. Well, for the information of everyone, well, I'm not siding anyone. I have yet to sit as member of the JBC, but then it should be remembered for a fact. Number one, when the president of this country appointed the Chief Justice, it was a Friday. And the initiation of the complaint was only made the following Tuesday. In fact, that was Tuesday of last week. Meaning the appointment preceded the initiation. So, but anyway, be that as it may, just to shorten up your concern, insofar as this chair is concerned, you are not a complainant in this case.
But, Mr. Chair, may I be allowed to participate in the proceedings?
You cannot, because under the rules, you're not even a complainant, you're not even a member of this committee. And under the rules, the initial deliberation of the impeachment complaint should only be among members of this House Committee on Justice. And this is not only in consonance or in accordance with the internal rules of the House, but even following what we had, the decision that we had during the past proceedings in the past, that we cannot allow any member to participate, but a just mere observer. I'm really sorry.
Mr. Chairman.
Yes, Congressman Lagman.
Thank you. Just 2 points. One, the complainants filed the impeachment complaint on 23 August 2018. And that was before the Bar and Judicial Council made a short list for appointment of the new Chief Justice. As a matter of fact, we were complaining that the shortlist was prepared with undue alacrity, less than 24 hours after we have filed the complaint. So, when the President appointed now Chief Justice De Castro, the complaint was already pending. And a copy of the complaint was served on the Bar and Judicial Council. Number 2, Mr. Chairman, I think there is no problem without a solution. In the case of Representative Villarin, most probably he can be allowed to subscribe and swear to the impeachment complaints before the Secretary, with the SecGen of the House of Representatives, so that he can be accommodated and recognized as a complainant in this case. I don't think there is any rule which will disallow him from signing and swearing before the SecGen on this particular complaint. He was actively participating in the preparation of this complaint. And like the other complainants, he has personal knowledge of the allegations therein, as well as has appreciated the authentic documents attached to the complaint. Thank you, Mr. Chairman.
Thank you, Congressman Ligman. Yes, you're recognized, Congressman Garbin.
Thank you, Mr. Chair. Just to add to the grounds relied upon by the chair on denying the participation of Congressman Villarin, those formalities, Mr. Chair, on affixing the signature and taking a note to be considered as one of the complainant in the impeachment complaint must be done before the impeachment complaint were referred to the or included in the order of business and referred to the Committee on Justice. In the absence of those formalities, Your Honor, I think it cannot be cured because this was already referred to the appropriate committee, which is now hearing this impeachment proceedings. Thank you, Mr. Chair.
Mr. Chair.
Thank you, Congressman Gerbin. But of course, before we recognize Congressman Nominal, I would like, of course, to acknowledge the presence of the following honorable members who are here present with us. Deputy Speaker Sharon Garin, Representative Dante Marcoleta, Representative Arthur Defensor, Representative Roy Loyola, Representative Luis Campos, Representative Rob Rocamora, Representative Fred Castro, Representative Edward Maceda, Representative Lito Atienza, Representative Harlene Abayon, and Representative Arthur Yap. Yes, Congressman Ominal, you are recognized.
Thank you very much, Mr. Chair. This is just a short response to the manifestation of the Honorable Villarin. Out of liberality, probably we can accommodate his plea. However, there are just legal predicaments that probably would be addressed if ever we will have to accommodate. Because under Section 3 of our Rules of Procedure in Impeachment Proceedings, which is approved by the plenary, not only by this committee, a verified Section 3 thereof, a verified complaint for impeachment by a member of the House shall be filed with the office of the Secretary General and immediately referred to the Speaker. Meaning, the signing of the complaint must be done before the office of the Secretary General, so that if he will have to sign it and administer the oath before this committee, whether or not this committee has the power to administer that oath and allow him to sign before this committee, considering that this rule of procedure in impeachment proceedings was approved by the plenary, not by this committee. Thank you very much, Mr. Chair.
Thank you, Congressman Mel. Your manifestation is noted, but at any rate, we'd like to repeat that the authority, actually, the matter in question is actually replete with jurisprudence. But then if the good congressman would like to avail of his remedy, he may do so, but not before this committee, because he has to make it before the Secretary General. At any rate, we have to proceed, and the matters that were raised are actually noted. Now, I would like to remind,
Mr.
of
Chair.
course, our members here that we're dealing with 7 individual complaints. It's not actually arising out of one petition or one complaint, but 7 separate complaints, meaning the 3 of them, Congressman Ezel Agman, Congressman Alejano, and Congressman Teddy Bagilat, filed 7 impeachment complaints. 1 for Chief Justice Teresita Leonardo de Castro, and individual complaints for the other 6 associate justices. Now, in order to, I would like to lay it before the body or for the members to decide whether to treat these complaints individually or to treat it jointly or be consolidated
Mr.
under the
Chair,
circumstances.
Can I be recognized, Mr. Chair?
Yeah.
Before we...
The chair has still the floor. And,
Sorry.
Yeah, I would like just to remind everyone that before we proceed, because after this we have to proceed with the determination of the sufficiency of form. But prior to that, there is actually a preliminary matter that I have in mind on how to treat these 7 complaints.
Mr.
Okay,
Chair.
I think we have to
Mr.
recognize
Chair.
first Congressman Rocamora, then Congressman Gerbin.
Thank you, Mr.
Congressman
Chair.
Rocamora, you are recognized. Please proceed.
Thank you, Mr. Chair. This is reference again to the issue regarding Congressman Villarin's failure to sign his complaint. I understand that rules are there to put order into our proceeding. But ultimately, what we want is to secure the truth. As a member of this committee, I had always hoped that perception would be that we are really impartial.
Okay.
So my problem is this. It's not really a problem. My concern is this. I would hate for that moment when the public perception is that we're trying to muffle the truth. Failure to sign is basically a matter of form. We can always consider this so that we will not give that perception that we're trying to muffle the truth here. I think it's a very simple thing for us to consider. So with that, I ask that the chair reconsider its ruling regarding the issue of Congressman Villarin's failure to sign. Thank you, Mr. Chair.
Thank you, Congressman Rocamora. But with all due respect, it's only your opinion regarding the muffling of the truth here. But as I said, the chair has already ruled. In fact, we cannot act on this in the request, considering that's really an unsigned pleading. But at any rate, does it make any difference if Congressman Tom Villarin will be a complainant or not? After all, the same allegations as he signed, he wanted to sign, was actually signed already by the 3 other congressmen. So I think it doesn't really matter here.
I would ask the same question. Would it really matter if he is allowed to sign it?
Yes, it would matter because that would be violation of the rules. I think that's clear.
Thank you. Thank you.
Congressman Marcoleta, you have something to say?
Yes, Mr. Chair. As a matter of fact, I will just have to repeat what you said because it will not make the complaint or the complaints less truthful if our colleague Tom Villarin will be unable to sign it. As a matter of fact, 1 signature is even sufficient, but there are 2 signatures already. It's unfortunate that he was unable to sign, but that is not his fault, but that is his own lookout. It is complicated if he will be allowed to sign it because as a matter of procedure, we cannot undo the procedures that we have to hold. Like for example, is referral to the committee. From the Committee of Rules, we have to take it up. And the Committee of Rules will have to adopt it. We did that with all the due processes and without the signature of our colleague Tom Villarin. But the truth is here, it's before us. He was unable to sign it. There's no problem about that. But the completeness and the efficacy of the complaints are not diminished, Mr. Chair. Thank you very much.
Yes, thank you, Congressman Marcoleta. Yes, Congressman Gerbin.
Thank you, Mr. Chair. Now, on the committee proceedings, we are about to delve on the sufficiency in form. But before we go in determining whether the 7 impeachment complaints are sufficient in form, Mr. Chair, a perusal of the respective impeachment complaint for the respondent, Chief Justice, and 6 justices reveals that the grounds laid down in Article 1 and Article 2 are all identical for all the respondents. Moreover, in the case of Chief Justice and 4 other justices, the paramount ground, which is their respective refusal to recuse themselves from the co-warrant of proceedings against the former Chief Justice Sereno, as laid down in the respective Article 3 of the impeachment complaint, are also identical. Now, Mr. Chair, while the rules of procedure in the impeachment proceedings do not have explicit rules on the consolidation of trials of the impeachment proceedings instituted separately, Rule 7, Section 16, however, of the impeachment that governs this proceeding states that the rules of criminal procedure of the rules of court applies to impeachment proceedings before the House. And let me state Section 22. It says, consolidation of trials of related offenses. Charges for offenses founded on the same facts or forming part of a series of offenses of similar character may be tried jointly at the discretion of the court. Consequently, Mr. Chair, under Section 1 of Rule 31 of the Civil Procedure, Rules of Civil Procedure, it states when actions involving a common questions of law or fact are pending before the court, it may order a joint hearing or trial of any of or all of the matters in issue and the actions. It may order all the actions consolidated, and it may make such orders concerning proceedings therein as may tend to avoid unnecessary costs or delay. Now, the reason for consolidation, Mr. Chair, has been discussed by the Supreme Court, wherein in the case of Neri versus Sandigan Bayan, the High Court stated that the rule allowing consolidation is designed, among others, to avoid multiplicity of suits, guard against suppression and abuse, and attain justice with the least expense and vexation to litigants. Also, in the case of Caños versus Peralta, the Supreme Court said that the court may order several actions pending before it to be tried together, where they arise from the same act, event, or transaction, involve the same or like issues, and depend largely or substantially on the same evidence, provided that the court has jurisdiction over the cases to be consolidated and that a joint trial will not give one party an undue advantage or prejudice to the substantial rights of any of the parties. Similarly, the court held that it is a time-honored principle that when two or more cases involve the same parties and affect closely related subject matters, they must be consolidated and jointly tried in order to serve the best interests of the parties and to settle expeditiously the issues involved. In other words, consolidation is proper wherever the subject matter involved and relief demanded in the different suits make it expedient for the court to determine all the issues involved and adjudicate the rights of the parties by hearing the suits. Now, based on the foregoing, Mr. Chair, and considering that the grounds for impeachment are founded on the same facts or forming part of series of alleged offenses of similar character, I respectfully move, Mr. Chair, that the 7 impeachment complaints be consolidated. So moved, Mr. Chair.
Mr. Chairman.
Yes, before we proceed with the motion, we deal with the motion, may we recognize Congressman Edsel Lagman.
We could even avoid voting on this issue because the complainants agree that there is proper mode of consolidating the impeachment complaints. And we endorse the consolidation in order that we could expedite the process. With the colatilia, Mr. Chairman, with the colatilia that with respect to the culpable violation of the Constitution, 2 grounds, this would be against the 7 justices. But with respect to the blatant betrayal of public trust, it will be only against 5 of the respondent justices, namely now Chief Justice De Castro, Justice Peralta, Justice Bersamin, Justice Tiham, and Justice Hardedesa. Thank you, Mr. Chairman.
Thank you, Congressman Lagman. would like to recognize Congressman Ronzalo, please.
Thank you very much, Mr. Chair. In as much as we, of course, we highly commend the complainants themselves for agreeing for consolidating the 7 cases, subject, of course, to the culatilia that was mentioned by the Honorable Lagman. With that said, Mr. Chair, in as much as everybody is in accord with that particular proposition, and we respectfully note that this particular motion that was being presented by Honorable Garbin would really redound to the public interest of everyone concerned, not just the parties themselves, but the general public, in as much as we know that this will redound to the benefit in as much as it will lead to a more dispatch or disposition of this particular case. And we know for a fact also that we here in Congress are really facing a lot of concurrent or simultaneous hearings being conducted by the House of Representatives. With that said, Mr. Chair, I respectfully reiterate the motion of Honorable Garbin that we consolidate all the 7 cases, subject, of course, to the culatilia mentioned by the Honorable Lagman.
There being a motion?
Mr. Chair,
Okay, before-
my previous motion is to consolidate all the cases. But Congressman Salo adopted the modification introduced by Congressman Lagman.
Yes, that with respect to the third ground.
So let
basically,
me
all of
state.
these are consolidated.
Yeah.
Except that the culatilia being mentioned by the Honorable Lagman with respect to the 2 bases. With respect to the first base, it's really about for the culpable violation of the Constitution. It is applicable to all of the respondents. The seven. But with respect to the betrayal of public trust,
5.
it's only for the 5.
5 justices.
Thank you.
But Mr. Chair.
Yes, Vice Chair Ching Veloso.
We are talking here about consolidation of cases, not consolidation of causes of action. So does that mean, Mr. Chair, and may I inquire from the Honorable Lagman, that in effect, all the complaints, all the impeachment complaints will be consolidated, except that as we delve on the causes of action, we will be treating the cases of against Andres Reyes and Alexander Gismondo as limited only to Articles 1 and 2. Thank you, Mr. Chair.
The Honorable Vice Chair Veloso is absolutely correct.
Thank you, Congressman Lagman. Now, in view of those manifestations, Congressman Garbin, would you like to reform and restate your motion?
Yeah. I respectfully move as follows. Consolidation of the cases for the grounds identical to all the respondents, namely Article 1 and Article 2 of the respective impeachment complaints for the Chief Justice and the 6 justices of the Supreme Court. And number 2 is consolidation of cases for the ground as laid down in Article 3 in the respective impeachment complaints against the Chief Justice De Castro, Justice Lucas Bersamin, Peralta, Hardilesa, Tiham, only insofar as the grounds are founded on refusal to recuse. I so move, Mr. Chair.
There's a motion and a second. An objection? Considering the motion has been seconded with no objection, the motion for consolidation is approved. Now, we will now go first, of course, after the consolidation of cases as a preliminary matter, we'll now go directly to the meat of the matter. And that is under the rules, specifically Rule 3, Section 4. The complainants have to prove before this committee that the complaints, 7 complaints, actually passed or would actually pass the test of sufficiency in form. May we recognize the complainant, Congressman Ed Seligman?
Thank you, Mr. Chairman. with respect to sufficiency in form, the following matters should be underscored. 1. Sufficiency in form is determined principally by finding whether the impeachment complaint or complaints are verified or not. 2. The instant complaints are duly verified in the form consistent with the rules of court and Section 13 of Rule 4 of the Rules of Procedure in Impeachment Proceedings of the House of Representatives. 3. The standard requirements of a ballot verification are: A. The allegations are true and correct based on the personal knowledge of the complainants, and B. The truth and correctness of the complainants' averments are additionally based on their appreciation of the authentic records and documents which are attached to the complaint. The verifications in the separate complaints precisely affirm and complied with the foregoing requirements. 4. Moreover, the facts alleged in the complaints are of public knowledge and or the proper subject of judicial notice, like A. The proceedings before the House Committee on Justice on the impeachment complaint against Chief Justice Maria Lourdes Sereno, which recorded the respective testimonies of the respondent justices. The attached pertinent certified true copies of the transcript of stenographic notes of said proceedings indelibly recorded the betrayal of public trust of respondents De Castro, Peralta, Bersamin, Hardelesa, and Tiham when they refused to inhibit themselves from the co-warrant to petition despite their admitted continuing ill will and prejudice against Sereno. B. The decision of the Supreme Court dated 11 May 2018 in the case of Republic versus Sereno, a certified true copy of which is also attached, as well as the concurring opinions of the respondent justices also attached, evince the respondent's culpable violation of the Constitution. Section 1 of Rule 129 of the Rules of Court provides, among others, that, and I quote, the official acts of the legislative, executive, and judicial departments of the Philippines, unquote, shall be accorded judicial notice. Verily, the personal knowledge of the complainants is coupled by the judicial notice given to legislative acts, like the proceedings in the Committee on Justice and the subject decision and concurring opinions in Republic versus Sereno. And 5, finally, relevant jurisprudence and the practice of this committee accord liberality in the assessment of the adequacy and sufficiency of a verification. Thank you, Mr. Chairman.
Mr. Chairman. Thank you, Congressman Lagman. About Congressman Alejano, would you adopt the manifestation or the comments of Congressman Lagman?
Thank you, Mr. Chairman. I adopt the statement of Honorable Edsel Lagman. In fact, I am one of the signatories of this letter to your committee. Thank you very much.
Thank you. Congressman...
Mr. Chair.
Yeah, we'll first recognize Vice Chair Ching Veloso, then Vice Chair Henry Obenal.
Mr. Chair, Section 2 and 3 of the Rules of Procedure in Impeachment Proceedings speak only of verification of a complaint, this being a complaint of members of this House. We do not have to go into the merits of the complaint. We do not even have to go into whether or not the complaint mentions matters of judicial notice. There's only one thing we have to inquire into, the determination of sufficiency in form, whether or not the complaint is verified. And I see that the complaints have been verified. It is therefore the position of this representation, Mr. Chair, that in my view, the complaint is sufficient in form.
Mr. Chair,
Yes, Congressman Henry Minal.
before this representation would move for the appropriate action on this particular issue, I would like to ask a question from the complainants here, Representative Gali Alejano and Representative Itzel Lagman. On page 54 of your verified complaints, that affects your signatures. And below your signatures is below the signature, your signatures above your names, there appears here a signature of a solemnizing officer, notary public, whose name was not indicated therein. May we know whose signature is this?
That is the signature of the Secretary General of the House of Representatives.
Okay. Thank you very much, the Honorable Lagman. In view thereof, and as fully affirmed and explained by Senior Vice Chair, the Honorable Veloso, that all these complaints have met the requirement of sufficiency in form. In this connection, I therefore move that all the complaints which were just consolidated earlier, there exists a sufficiency in form.
I
therefore
second,
move to
Mr.
that
Chair. Second, Mr. Chair.
Yeah, there's a motion, but then under previous precedents that we have, in order to find or to rule on the motion, for those who are in favor of the motion, please rise. For the information of everyone, we're voting on the motion
Determination of sufficiency in form.
sufficiency in form of the impeachment complaints. Thank you, my dear colleagues. Please sit down. For those who are against the motion, please rise. Kayong dalawa? Hindi pala. There being 21 in favor of the motion that the impeachment complaints are sufficient in form, we have 21 members voting in the affirmative, 0 against. So the motion is approved.
Mr. Chair.
Okay, we'll now proceed with the second.
Mr. Chair.
Yes, Congressman Ron Salo.
Thank you very much, Mr. Chair. Of course, in as much as the committee has already found the complaint to be sufficient in form, I suppose the next logical step is for this particular committee to vote whether there is sufficiency in substance with respect to the complaints that were filed. And we respectfully note...
I see we will
yes, Mr.
deal with that one.
Mr. Chair, in Section 4 of the Rules of the Impeachment provides that the requirement of substance is met if there is a recital of facts constituting the offense charge and determinative of the jurisdiction of the committee. I respectfully note, Mr. Chair, that yes, this particular representation has already received the complaints that were filed, and I respectfully note that they appear to be just quite voluminous. Yes, forgive me, Mr. Chair, while this particular representation has already read some of it, but I wasn't able to finish reading all the complaints that were filed. And certainly this representation would require sufficient time for me to be able to appreciate and to make a personal determination whether the recital of facts would really constitute defense charge and whether it was really determinative of the jurisdiction of this particular committee. Mr. Chair, with that said, I respectfully move that we suspend proceedings of this particular hearing and we reconsider, we resume again after, I suppose, most of our colleagues have already read the entirety of the documents.
Excuse me, before there's a motion, the parliamentary status, we have a motion. But then may I inquire first with the Secretariat if all members have been furnished already with the copies of the complaints?
Yes, Your Honor. All members have already been furnished copies of the complaints and the annexes, Your Honor.
All of them?
Yes, sir.
Okay. Yes.
I
when did you furnish them?
Your Honor, some of the members received their copies last Thursday, and some were distributed yesterday, Your Honor.
Okay.
Considering, Your Honor, that majority of the members of the committee were just furnished a copy of the voluminous complaints just yesterday, and some of the members were just elected in the floor last night, I joined the manifestation and the motion of the Congressman Ron Salo for the resetting of this case to afford each and every member the opportunity to appreciate, study whether there is really sufficiency in substance, recitals of facts that constitute the offense determinative of the jurisdiction of this committee. I second the motion of Congressman Salo.
There's a motion.
Mr. Chairman.
Yes, Congressman Lagman.
We have no objection to a short deferment of the setting in this committee with respect to the determination of sufficiency in form of the 7 impeachment complaints. In substance.
Okay.
And I would like to reiterate that as of yesterday, we have filed a letter justifying the sufficiency in substance.
We got it. The committee got it, Congressman Lagman.
And I would like to thank the chairman and the honorable members of the committee for determining that the impeachment complaints are sufficient in form.
The manifestation of Congressman Lagman is noted.
Mr. Chair.
Mr. Chair. Mr. Chair.
Yes.
I just want to inform the chair that this representation has not yet received the copies of the complaint.
Yes. Please take note of the request of Congressman Arbison regarding the furnishing of the complaints. If the Secretariat can make it, please furnish him with the copies of the complaint now. Yes, Vice Chair Veloso.
Mr. Chair, Article 3, Section 16 of the Constitution mandates that all persons shall have the right to a speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies, and that encompasses an impeachment proceeding. I therefore join the Honorable Lagman in seeing to it that our resetting be on
next Tuesday, September 11. Would that be fine with the complainants?
Yes, Mr. Chairman.
Okay.
Thank you, Mr. Chair.
Okay, there being, before we proceed with the adjournment, of course, our suspension. Number one, we declared that the complaints were sufficient, in form, and then with the motion and with no objection, the motion to suspend the proceeding is carried, and we'll have our next committee hearing on, or the hearing of these impeachment complaints on September 11, and that would be Tuesday, 9:30. Motion is, or the proceeding is suspended.